A Supreme Court decision just dropped that could change how gun laws get judged in every lower court. And almost nobody's explaining the real 9-0 twist the right way. Quick question before we continue, are you subscribed? Because what I'm about to reveal could save you from a decade in prison. Hit that button now and let's get into it. So here's the headline you clicked for, 9-0 unanimous. The Supreme Court just rewrote your Second Amendment rights. Now, I need to be careful and honest with you right up front. Most of the big, famous Supreme Court Second Amendment cases are not 9-0, like Bruen was 6-3, Rahimi was 8-1, but there's a very real way the court rewrote the rules in a way that affects gun rights fights across the country. And the key is this. The court has been tightening and clarifying the tests lower courts must use, meaning the rules of the game. Today, I'm going to break down 3 Supreme Court decisions that form a 1-2-3 punch for gun owners and gun laws. First, United States v. Rahimi, 2024. The court explains what history and tradition really means after Bruen and tells lower courts to stop demanding a historical twin. Source second, Garland v. Cargill, 2024. The court shuts down the ATF's bump stock rule as beyond what the statute actually says. This isn't a Second Amendment case, but it matters because it limits agencies from creating gun bans by redefining words. Source. Third, the ghost guns rule case, Bondi v. Vanderstock. The court upheld at least some parts of ATF's rule under the Gun Control Act in a 7-2 vote, showing the court will sometimes allow ATF regulation if the statute can support it. That means the real battlefield is often going to be, what does Congress's text allow? Source. Now, let's walk through this like we're sitting at a kitchen table, not a law school classroom. Here's what just happened and why you should care. Segment 1, the 9-0 claim you keep hearing, and what's actually true. If you've been on YouTube or gun social media, you've probably seen big thumbnails screaming 9-0 Supreme Court win for gun owners. Here's what most people get wrong. They mash different cases together, or they take a case that's not actually a Second Amendment case and say it rewrote the Second Amendment overnight. So let me break it down for you. A Supreme Court decision can change your gun rights in at least 2 ways. One way is direct. The court says, this gun law violates the Second Amendment. That's the obvious kind. The second way is sneakier, and honestly, sometimes bigger. The court changes the legal method, meaning the step-by-step test lower courts must follow. If the method changes, outcomes change. Think of it like this. If your state changes the scoring rules in a football game, the same team might win or lose now. Not because the players changed, but because the rules changed. That's what's happening here. And the part that shocked me is that Rahimi, an 8-1 case, not 9-0, still gave lower courts a loud message. Stop treating Bruen like a copy and paste from 1791 contest. Source to the court basically said, you don't need a historical twin. You need a historical analog. In normal English, that means it doesn't have to be the exact same old law from the founding era. It just has to be similar enough in the reason and the way it limits the right. Source. That one idea changes how gun cases get argued, because before, some judges were doing this thing where they'd say, show me the exact same gun restriction from 1791 or you lose. And the Supreme Court is like, no, that's not the assignment. That's why people say it rewrote things, not because it deleted the Second Amendment, but because it clarified how Bruen works. Now, this is where it gets interesting, because Rahimi was about disarming someone under a domestic violence restraining order, a federal law called 18 U.S.C. 922G8. Source. And the court said, if a court has found you are a credible threat to someone's physical safety, the government can temporarily disarm you, and that can fit history. Source. So if you're thinking, wait, how is that good for gun owners? Here's how. The court did not say anything goes. It tied disarmament to a process, a court finding, a credible threat finding, and a temporary restriction. It compared it to older surety laws and going armed laws, old systems meant to stop threats and intimidation. Source. In other words, the court is sketching the boundaries, and boundaries matter. Because if the boundary is credible threat after a court finding, then a lot of broad laws that treat normal, peaceful people like criminals become harder to defend. That's the part nobody's talking about. Segment 2, the agency ban problem, bump stocks, and the power to redefine words. Now let's talk about Garland versus Cargill. This case is about bump stocks. And yes, I know. People have strong feelings about bump stocks. Put that aside for 60 seconds. Because the real issue in Cargill is bigger than bump stocks. It's this. Can an agency like the ATF take a law Congress wrote and stretch the words until your previously legal item becomes a felony? In Cargill, the law defines a machine gun and something that fires automatically more than one shot. by a single function of the trigger. Source. The ATF had said for years that bump stocks were not machine guns. Then after Las Vegas, ATF flipped positions and made a rule saying bump stocks are machine guns and people had 90 days to destroy or surrender them to avoid prosecution. Source. The Supreme Court said, no, ATF exceeded its authority. A bump stock-equipped semi-auto still requires the trigger to reset between shots, and it doesn't fire multiple shots by a single trigger function the way the statute requires. Source. Here's why that matters to you, even if you hate bump stocks. Because the same redefine the words trick shows up everywhere. Today it's machine gun, tomorrow it's receiver, or frame, or readily converted, or designed to. If the government can win by simply changing definitions through a rule, then your rights are only as stable as the next rulemaking. And Cargill tells agencies, you don't get to do that just because you want to. If Congress wants a ban, Congress needs to write it. Source. But wait, there's something even more important. This isn't just about rights. It's about how fast you can become a criminal without knowing it. Imagine you bought something legally, you passed a background check, you put it in your safe, then a rule drops, it relabels your item. Now it's contraband. If you miss the news, you don't just own the wrong accessory. You could be looking at federal charges. That's why these cases matter. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. Segment 3, Ghost Guns. Why the court sometimes lets ATF regulate and why that should worry you. Now, let's hit the third piece, the ghost gun rule case. This one is tricky. SCOTUS blog explains the Supreme Court upheld a Biden-era rule regulating at least some ghost guns under the Gun Control Act by a 7-2 vote. Source in Justice Gorsuch's opinion focused on how the statute's words can include some weapon parts kits that can be readily converted into a functional firearm. He used an example kit called Buy, Build, Shoot, pointing out the kit comes with all necessary components and its purpose is obvious. Source. Here's the key detail most people miss. The challengers were asking for a total wipeout of the rule in every possible application. The court basically said, you haven't shown it's illegal in every application, so we're not nuking the entire rule. Source. And here's what should make you sit up. This means gun regulation fights are becoming a two-front war. Front one is the Second Amendment, history and tradition fight after Bruen and Rahimi. Source, front two, is the statutory text fight, what Congress's words actually allow agencies to regulate, like in Cargill and the ghost gun rule case. Source. And if you're a normal gun owner, here's what that changes for you in real life. First thing, you can't assume this is a Second Amendment issue means the Second Amendment case law will save you. Sometimes the court never even reaches the Second Amendment question. Sometimes it's about what the statute says. Second thing, you need to pay attention to what category you're in. Are you a normal, law-abiding adult buying a complete firearm through an FFL? Different fight. Are you buying kits, unfinished parts, or building at home? The rules get fuzzy fast, and fuzziness is dangerous in criminal law. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Segment 4. Rewritten rights, in plain English. What Rahimi really changed for future gun cases. Let's go back to Rahimi, because this is the case that will quietly shape everything else. In Rahimi, the Supreme Court told lower courts, stop looking for a historical twin. Look for a historical analog. Source. That sounds small, but it's huge, because it changes how both sides argue. Gun control states will argue, we have a historical analog for modern restrictions, because old laws also tried to stop dangerous conduct. Gun rights challengers will argue, your modern law is broader than the old analogs. It hits peaceful people. It's not tied to a court finding. It's not temporary. It's not about a real threat. Here's a hypothetical example to explain this. Imagine your state passes a law saying, if you've ever been accused of being rude in public, you can't own a gun for 5 years. Most people would say, that's insane. Under the Rahimi logic, a court will ask, what is the reason and how does it burden the right? Is it aimed at stopping real threats of violence? Or is it sweeping up normal people? Is it tied to due process, like a real hearing and a finding? Or is it just a label? And that's where a lot of laws could break. Because Rahimi emphasizes a court finding of a credible threat. Source. So if a law disarms people without a real individualized finding, it may be easier to challenge. Also, Rahimi reminded everyone that facial challenges are hard, meaning it's hard to kill a whole law in one shot, because you have to show it can never be constitutional in any situation. Source. That pushes future lawsuits toward narrower, fact-specific challenges. So what does that mean for you? It means your exact facts matter more than ever. Your paperwork matters. Whether you had notice and a hearing matters. Whether there's a written finding matters. And if you don't know that, here's what could happen. Imagine you're at a traffic stop. You're calm, you're polite, but you're under a restraining order you think is just paperwork from a messy breakup. If that order meets the federal criteria, possessing a gun can become a federal crime under 922G, Writer 8, source. That's not a scare story. That's exactly the kind of law Rahimi was about. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. Segment 5. The real takeaway. Your rights didn't even vanish, but the fight just changed. So did the Supreme Court rewrite your Second Amendment rights? In a way, yes, because Rahimi clarified the Bruen test and told lower courts to stop demanding perfect historical matches. That changes outcomes. Source. But in another way, no, because the court is not saying the Second Amendment is whatever the government wants. The court keeps repeating that the right is fundamental but not unlimited. Source. What's really happening is this. The court is building a system where if the government wants to disarm you, it needs a strong reason, it needs a process, and it needs history that's close enough in purpose and burden. But if you're clearly found to be a credible threat, the government can temporarily disarm you. And if an agency wants to ban something, it can't just wave a wand and redefine statutory words, like in the bump stock case. Source. At the same time, the ghost gun rule case shows the court will sometimes accept ATF authority if the statute can reasonably cover certain kits or unfinished frames. Source. So here's my warning to you. Don't make this mistake. Assuming every gun case is a Second Amendment case, sometimes the court decides it as a text case, a definition case. And that means elections, Congress, and the exact words in statutes matter more than people want to admit. This information could literally expire after January 2026. Subscribe now because the next video explains exactly what you need to do before that deadline hits. Now let's land the plane. The key takeaway is simple. The Supreme Court is forcing courts to stop playing games with the Bruen test, and it's forcing the government to be more precise about how it regulates guns. But it's also making clear that if a court finds you're a credible threat, you can lose gun possession rights temporarily. Source. If you want straight, no-drama updates that keep you legal and keep you informed, subscribe right now. I make these videos because I don't want you learning this stuff from a prosecutor. And final disclaimer, in plain terms, I'm not your lawyer. This is general education, not legal advice. Laws change, facts matter, and your local rules may be different. Always talk to a qualified attorney in your state if you need personal legal help.